Before we get to the next case, let me welcome the students from Marshalltown High School. I'm so glad you're with us this morning, and I hope you enjoy the proceedings. The next case then is Iowa State Education Association and Davenport Education Association versus State of Iowa and others. So, Brian, you may proceed.
Thank you, Your Honor. May it please the court, I am Alice O'Brien. I am here on behalf of the 33,000 teachers and education support professionals who work in Iowa public schools and who come to this court for relief from the discriminatory classifications that the legislature adopted in 2017 by passing House File 291. I'd like to focus my argument today on the second prong of the test that this court applies under Article 1, Section 6, and that test is whether or not the state interest that's proffered has a reasonable basis in fact. Is it conceivable rather than specious that that is the purpose for the classification in the statute? And the starting point here, as some of the colloquy earlier suggested, is what the legislature said it was doing. And here both the plaintiffs and the defendants, the state and the union, have submitted the relevant portions of the legislative transcript. The legislative transcript clearly reflects that the reason for the classification that was adopted in the discrimination and bargaining rights was the need to give police and fire, who risk their lives every day, the ability to go to the table to address the special health and safety needs that they have because they, every day on the job, go into dangerous and unregulated environment. Those were the explanations that were offered in the Senate by Senator Schultz, who managed the floor debate in the Senate, who was the chair of the Labor Committee, the leader in the Senate on this issue. It was the explanation offered by Senator Zahn, who explained that he went to Senator Schultz in order to get the exemption for police and fire into the bill. It was the explanation on the House side as well by Representative Holt, who was managing the debate on the House side. And consistent with this court's precedents, that legislative purpose has to frame the analysis under the second prong of the Article 1, Section 6 test.
Couldn't there be more than one purpose?
Yes, there certainly can be more than one purpose, but we would submit, as this court did under Racy, where it looked to the Legislative Study Commission and said that the Legislative Study Commission contradicted an asserted purpose, that the legislative purpose, which is articulated by the legislature, articulated in the legislative record, frames the analysis. Similarly, this court in...
Yes, could you then apply that rationale here and point us to anything in the record that contradicts the stated or preferred purpose?
It depends on which purpose you're talking about, but the purpose here, the legislative purpose to give police and fire special rights to bargain health and safety issues does not match or explain at all the bargaining discriminations in the bill. Because number one, it gives police and fire far more rights to bargain over other issues besides health and safety. Number two, it strips away from everybody who is subject to the repeal all rights to bargain, and it prohibits employers and unions who are subject to the bargaining repeal from bargaining over central issues in labor management relations that are totally unrelated to health and safety.
You know, for much of my legal career, there was no legislative history, and only in recent years do we have the video of the Senate debates and whatnot. But is there any case where we've said if some senator doesn't say it on the record that the court can't consider that in determining whether there is a rational basis for legislative classification?
That's not the position we are urging here. It would be a different case if the legislative purpose was not clear from the legislative record. In that case, the court obviously needs to look to any available sources of evidence, as it did in the Varnum case, to determine whether or not the purpose it is credible rather than
Now,
specious.
Varnum was an intermediate scrutiny, correct?
Correct.
Okay, under rational basis, can't the court consider conceivable reasons as long as they're not contradicted by the record? And is there anything in the record in this case that contradicts a labor peace or strike avoidance goal?
Yes, so the entire record contradicts the notion that the need to give police and fire special bargaining rights because they have special health and safety needs. The whole tenor of the legislative debate is directly at odds with the premise, which the state is offering here, that you needed to preserve police and fire bargaining rights because otherwise they would not just walk off the job, but they would violate the law and risk their jobs and risk imprisonment under this state's laws. Notwithstanding the fact that in this state's history, there has never been a public sector strike since HERE was adopted.
Ms. O'Brien, let me follow up on Justice Waterman's question. I was involved in RACI as one of the lawyers, not as a member of this court. And as I recall, the reliance of the Supreme Court, our court, on the Legislative Study Commission was because that disproved one particular, it directly contradicted one particular conceivable rational basis that was being offered by the state. It wasn't a situation, what you seem to be talking about, which is you're saying, well, legislators here were making statements in support of one possible justification, and therefore the state can't rely on other justifications. That seems to me a different issue, and that isn't what RACI 2 holds, is it?
So RACI 2 looked to the Legislative Study Commission for two purposes. Number one, it said the Legislative Study Commission supported some tax differential between the riverboats and the casinos, a 4% tax differential, but that didn't support the 16% tax differential. And number two, it said that the Legislative Study Commission did not find that giving the riverboats the preferential tax treatment, did not find or address that giving the riverboats the preferential tax treatment was necessary to prevent them from moving out of state. So I think this court's use of the legislative record in RACI is exactly in line with what we are urging this court here. And this court in subsequent precedents, and Tyler, for example, looked to RACI and said, RACI is a case in which the legislative record belied the asserted purposes, belied two of the asserted purposes here. We are not saying that the state can't proffer other asserted purposes that are not contradicted by the legislative record, but we are saying that the asserted purpose of making sure that police stay on the job is belied by the legislative record here, because the legislative purpose was to ensure that police and fire could bargain over special risks, not to keep them on the job. There was no suggestion, and it would be entirely at odds with the supposition that the uniformed services, risk their lives every day. The notion that they would not just walk off the job and not do their job, but they would risk their jobs and risk their liberty under the laws of the state.
Agree that Tyler, which I think I wrote, accurately summarizes the post-RACI 2 rational basis analysis. Is that right?
Yes, and in Tyler, this court noted that the parties in Tyler stipulated there was no relevant legislative record. For further proof on this point, look at 2 LSCP. And this court looked for federal equal protection purposes at what the legislator might have wished to achieve. But for the Article 1, Section 6 purposes, this court looked to what the legislator said it was doing. It's quite a different analysis. And our point...
Hypothetically, if the legislature for these amendments had included a statement of purpose or legislative findings that set forth avoiding strikes to protect public safety as a reason, would that be constitutionally valid then?
We submit it would not be, given the history in this state. We have 44 years of labor peace in this state. It's undisputed, and that is so because the penalties against striking in Iowa are so draconian and severe. Even the state admits that the penalties are far more severe than they are in the neighboring state of Wisconsin. And nobody is going to walk off the job and risk their job and liberty to go on strike. The legislature, when it enacted the Public Employment Relations Act in 1974, one of its purposes was to prevent strikes. It put those draconian penalties in there to do that. They have been 100% effective. The 2017 statute did not change that in any way, and there have been no strikes either before or after the 2017 adoption. In addition, to go to the 30% issue, if the legislature's concern here was really keeping police on the job in order to ensure that against the public peril that would result if they walked off their job, there is no rational basis at all for the 30% rule. You would just do, as they did in the case of Wisconsin, and grant police bargaining rights that are different from everyone else. But here they didn't do that. Here they granted bargaining rights to bargaining units based on whether or not they had 30% at least of these certain job categories. That includes some, but not all police in the state of Iowa, and that includes some, but not all firefighters in the state of Iowa, and that include other employees that really have nothing to do with public health and safety, like park rangers and gaming officers.
Will you be getting to the payroll deduction, the taking away the automatic payroll deduction issue?
Yes, I would love to, Your Honor. So as to the payroll deduction, the classification here is that the 2017 statute bans the use of payroll deduction for union dues and only union dues. And that is so despite the fact that state law allows for deductions to employee associations, which is undisputed on the record here. The Iowa State Education is both an employee association and a union, and state law allows deductions for other trade associations and school districts. Prior to the 2017 statute allowed payroll deductions for union dues. And the statute bans such dues deductions even if the employer would like to allow them, as Superintendent Taylor said in his affidavit, which is submitted in this case, even if it costs the school district more to remove the deduction than it does to continue the deduction, as Superintendent Taylor said in his affidavit in this case, and even if the union offers to pay all the costs of the deduction. And
What's the impact of that, Ben?
what's the impact of the ban? The impact of the ban is that unions and only unions are not able to use payroll deductions to collect dues, and employees are unable to use the convenience of payroll deductions to pay their dues.
Does the record show whether this has caused a reduction in union membership or union revenues?
No, Your Honor, it does not. It does not.
Hypothetically, if the state had never offered or allowed an automatic payroll deduction for union dues, could a public union sue to compel the state to implement such a system?
No, our contention is not that the state must provide it. Our contention is if the state does choose to provide it, it must provide it in a manner that complies with the Iowa Constitution. And here,
So if employees, if a teacher can use automatic payroll deduction for United Way contributions, but not union dues, that's unconstitutional?
I think that's a different case, Your Honor. Here, what we're saying is employee associations Some employee associations can continue to use payroll deduction to collect their dues. Other employee associations who fulfill the statutorily mandated duty, because the state policy of Iowa is still in favor of public sector bargaining, unions still are required as a matter of state law to engage in bargaining, albeit within the limited scope of the 2017 statute. Only those groups who would have to engage in a state mandated activity are disabled from seeking payroll deduction, and we submit that that classification is irrational. And with that, I see my time has almost expired, so I will sit down. Thank you.
Ms. O'Brien, thank you as well. Mr. McDermott, you may present your argument.
May it please the court, counsel. My name is Matt McDermott, and I represent the defendants in this action. I'll address the challenger's argument about whether or not something actually needed to be in the legislative record about the basis that justify HF 291. This court has been clear in Racy and thereafter, and including in the recent Tyler case, that the second prong of the rational basis test is whether the interest is realistically conceivable and does it have a basis in fact. And the court's analysis explicitly does not require proof as we typically understand that. The analysis is not in the sense that the grounds for the legislation aren't correct. The analysis is whether there is a sense that they are so far off the mark that the legislature could never have rationally believed them. And so the argument that the challengers have made here, that there must be some evidence of this in the legislative record, and that the absence of it here means that there isn't any rational basis, must fail.
Well, yeah, aren't we really searching for what's really the truth here? And it's sort of like, how deep are we going to search for it? And what should we require the legislature to tell us about their purpose and rationale behind their legislation? So should we require them to come forward and be a little more specific and give us greater understanding of the purpose of their legislation?
Under the rational basis test, there's never been any requirement that legislatures do that. And putting that burden on a legislature could conceivably mean that legislative debates take much, much longer than they currently do.
But doesn't that then put the burden on us to, the bottom line is we're still trying to identify what's the truth. That's what courts do. And now we have to go out and try to surmise, well, what could have really been going on here that's consistent with our constitutional framework.
With respect to the constitutionality of a law, we start from the baseline that the law is constitutional. And the court tries to find every possibility or every avenue that it can to uphold that. And so if that means that this court has to conceive of basis for the statute that keeps it in place, that's what the court must do. In this instance, we have 150 legislators and a governor that were part of this bill. It isn't appropriate to think that we're going to put 150 legislators on a witness stand and ask them what their rationale was for passing this.
I agree with that, but nonetheless, the notion of and I'm going back to what you said in the earlier argument, what does this mean? What does the statute mean? And I mean, in 1001 context, we look through the legislative history. A snippet from some legislator buried in the record, salted in the record maybe, might be designed to distort rather than to elucidate. I think the high water mark of your opposing counsel is, the comments that were in the record were not random comments at all. They were made by people with significant responsibility in the legislative process. Isn't that entitled to, some weight in looking at what the legislature was, attempting to accomplish?
Under the rational basis test, we're not required to limit ourselves to what that debate said. And if you read what the debates were, it was frequently answering questions. It wasn't affirmative speeches about it. It was answering questions about it. And so the legislators weren't required to one by one go to a podium and explain what they meant. And here again, we have a very limited record of what the legislature actually intended by this. But under the rational basis test, we have a means of trying to figure out what a conceivable rational basis for this legislation was. And here I think it's pretty, sorry.
No, there's a case involving florists in Louisiana. Maybe you're familiar with it, but Louisiana passed a statute that basically required florists to be licensed, and some entrepreneurs challenged it, license for florists. The arguments offered included, health, people's health, florists promote health, and that the arrangements might not be adequately done by a non-licensed florist. And these were proffered as, kind of conceivable reasons. You look through the legislative record, you can't find anything to say that's not it. The problem with the conceivable basis is that, there could be 1,000 conceivable bases. Proving the negative, is a difficult task, and what you're basically, I think, requiring ISE and others to do is to prove the negative of not only the proffered rationale you're suggesting, but maybe 1,000 other rationales. And is that unfairly putting a burden on the challenger?
Not at all. That is correct. Under the rational basis test, again, it is to uphold a statute.
You'd uphold the florist statute?
Well, it'd have to be subject to the rational basis test. The court determines whether a statute is constitutional or not, largely based upon the test that is applied. And here we're talking about social or economic legislation. So it's subject to the rational basis test. And as this court has set out repeatedly what the factors of that test are, it passes. It passes here. And we don't have to look to what the few legislators that actually spoke on this topic said to determine what the rational basis for other legislators or for the legislation at all is.
About the checkoff, can we switch gears on that? I'm interested in that. I think the court's generally interested in it. What's the rationale for saying that the checkoff is not something that ISEA can use?
The checkoff here was removed not just for non-PSEs, and in Wisconsin, this was challenged also, and there they kept the checkoff in place for PSEs and they removed it for non-PSEs. Here it is removed for everyone. And so I think that there's a
all collective bargaining.
All collective bargaining.
Yeah, okay, so there's a classification. Collective bargaining groups can't use the checkoff. Other type groups can. And what's the rational basis for that?
Well, it's only under Chapter 20, and so Chapter 20 only deals with organizations that, like the ones that we're talking about here. There isn't a prohibition generally that others couldn't use it. What the state is saying is that as to the state, which the legislature is permitted to determine, as to the state, we're not going to have it any longer.
Mr. McDermott, on the checkoff, we have a thing called the Iowa Judges Association, and those of us who belong to it, including me, it's a voluntary organization, kind of joke about it and call it the Judges Union. And its primary purpose, it hasn't been very successful at it in recent years, is to try to get our pay increased. They haven't taken away that checkoff. What's the difference?
Association rights and union dues are different. Association rights actually do involve a First Amendment right. Dues checkoffs do not. The Ibarra case that the U.S. Supreme Court looked at in 2009 addressed this issue directly, but not under a rational basis standard, but under a First Amendment fundamental right strict scrutiny standard. And there it failed. So when we're looking at this under a rational basis test, it clearly fails here.
Justice Waterman asked a question earlier of the other attorney, Ms. O'Brien, and had something to do with the effect, I believe, of, do you know of any authority where we cannot look to other reasons? And I'd like to ask that same question of you.
To the contrary, all of the authority that this court has set out says that the standard is one where not only can you conceive of things that aren't in the legislative record, you must under this standard.
But a lot of states go a different way. I mean, Minnesota, Maryland, Alaska, Indiana, New Jersey. I mean, a lot of states say that you don't go to hypothetical reasons because it's virtually impossible for a challenger of a statute to, I mean, it's like whack-a-mole, wham, wham, wham. They keep on popping up. In this case, we got 3 reasons, wham, wham, wham. And then in some cases, including this one, the court comes up with its own reason, wham, 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 wham. And that's a segue into my question now, which is, in this case, the court came up with a reason that was an elaboration, I think. Maybe challenge me if you don't think my characterization is quite correct. But it seemed to me the court came up with some additional reasoning to support the statute. And is that appropriate for a court to come up with a reasoning that hasn't been advanced by counsel to attempt to sustain a statute?
Yes, it is. It is under this standard.
Correct that that's what happened even. I mean,
in the AFSCME case, there was a rationale that was put forth about morale for PSEs that I think, again, could be wrapped into it. I don't think that there's anything wrong with that. I think that the simplest, most direct path to upholding this statute is thinking of it through the lens of the competing interests that the government had in trying to give flexibility to state and local governments in their budgeting, but also in preserving public safety. If there are no other questions, thank you.
Mr. McDermott, thank you as well. Ms. O'Brien, you may present your rebuttal argument.
Thank you. Our point is not that the legislature has to say anything about the purpose of the statute it adopts, but where the legislature does say something, this court's analysis has always considered that stated purpose in applying the second prong of the Article 1, Section 6 analysis. That is what this court did in Racy. It's what this court recognized in Tyler. The parties had failed to do because they failed to provide any legislative history for the court. And in Tyler, the court didn't demand that the legislative record that was presented directly contradict the purposes. It said correctly, based on what actually happened in Racy, that the legislative record in Racy belied the 2 of the asserted purposes there, because the legislative record in Racy, the study commission report, did not support such a large tax differential between the 2 types of slot machines based on location, and also did not say anything at all about the differential being necessary to prevent riverboats from moving to another location. Facts matter. That's what this court said in BEM just this past August for the second prong of the test. And here, what the legislature said about what they were doing in passing the draconian bargaining discrimination and impasse discrimination into law in 2017 must be considered by this court. The state has pointed to no case, and we are aware of no case, where this court has upheld a legislative classification that is at odds with the legislative record as to the purpose for why it was adopted. And if the court were to go down the road that the state is offering here, it would effectively collapse the distinction between Article 1, Section 6 jurisprudence and Federal Equal Protection Clause jurisprudence. We respectfully request that the court decline to go down to that path and uphold Article 1, Section 6 as a meaningful protection on the rights of Iowans to equal treatment under the state constitution. As a last gasp in the argument here, the state now points to a fourth reason, which is flexibility. And that reason, even under the deferential standards that apply under the Equal Protection Clause, was rejected as insufficient by the Seventh Circuit in the Weak v. Walker case because it does nothing to explain the discrimination at issue. So too here, the discrimination here is profound, and it is not about giving local communities flexibility over labor management issues. In fact, the statute prohibits altogether for bargaining units that are not exempted any bargaining over 7 subjects, which previously were core subjects of bargaining in this state. Even if the employer wants to bargain over them, even if the employer believes that bargaining over them is the most valuable and efficient way of resolving complicated disputes over matters like insurance, transfers, evaluations, and the record evidence before you from the Superintendent Taylor's affidavit from the Ames community is to exactly that effect.
Ms.
This-
O'Brien, I'd like to ask you a question. I'm afraid otherwise it's going to turn red on me. And we have rules up here. You were asked a question earlier, is there any authority that we can't look to for other reasons? And you said that's not what we're arguing. And then I asked that question of Mr. McDermott, and I'm coming back to you. I know it's not what you want to argue, but I'm very interested in an answer. Could you please answer for me? Is there any authority that we cannot look to other reasons?
Yes, I would submit that this court's decisions in Racy, LSCP, Tyler make very clear that where the legislative record speaks to the state interest, that necessarily has to be part of the inquiry under Article 1, Section 6, the second prong that has to be considered in determining whether or not the asserted purpose is realistically conceivable, has a reasonable basis in fact, or is specious. And here, the legislative record that frames the inquiry is about giving police and fire special rights to bargain health and safety. That is not what the 2017 statute does.
Okay, what's your authority? I'm looking for some authority that we cannot do that. Do you have any authority that we're not allowed to do that?
I think the authority are your past precedents, which have always looked to the legislative record. This
Can
court
you
has
name those?
never, Racy, Tyler, LSCP, are all cases in which this court has engaged in a different analysis under Article 1, Section 6 than applies under the Federal Equal Protection Clause. This court has never gone down the road that the federal courts have gone down to say that you can make up any purpose, even if it's totally at odds with whatever the legislature said they were doing. And we would submit that is the opposite of deference to the legislature here, where you are making up a purpose which you know the legislature would never embrace. It is not something that this court has ever done, and we would submit and respectfully request that the court should not do so now. And with that, if there are no further questions, that concludes my argument.
Mr. Bryan, thank you very much.
Thank you.
Mr. McDermott, thank you again. The case of Iowa State Education Association versus State of Iowa is now then submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.